Welcome back to TV5 News at 9. It's time now for Legally Speaking with attorney Carol Thomas. Thank you for joining us this morning.
Thank you, Lauren. It's great to be back.
Of course. So, Carol, today we are talking about elder law, estate planning, and trusts. As an elder law attorney, we know you help create trusts and wills. What other things can you help people prepare?
Well, I love that question because most people think about doing wills or trusts, and that's talking about what happens the day that I die. But most people don't think about the sad reality. What if there's an incapacity issue before I die? Who's going to make decisions for me? And so there's some very important documents. There's the medical power of attorney and the financial power of attorney.
All right. And what is the purpose of the financial power of attorney? Let's start with that one.
Well, the financial power of attorney, people don't think that they need one because, especially if you're married, my spouse is on with everything with me, but that's not necessarily the case. I had a husband last week that his wife has dementia. They never did powers of attorney, and now we're having to go to court because of her mental incapacity issue. So financial powers of attorney are extremely important, whether you're married, whether you're single, just to have someone handle your finances, pay your bills, and the most important thing it does for me in my office is if someone ever needs long-term care, if we have the right language in the financial power of attorney, we can protect people's assets, and that's so important.
And continuing that, can you also explain what is the medical power of attorney?
Well, the medical power of attorney also extremely important. People don't think they need it, especially when they're married. They think, oh, my spouse can make my decision. But legally, you need a medical power of attorney where you're saying, this is the person that I want to make my decision for me if I'm unable to make it myself, and also to be able to communicate with the doctor. And it's really important to talk to your loved ones about what your wishes may be if you get into the situation where you're no longer able to make your own medical decisions. And these documents are free at every hospital. So, Lauren, there really isn't an excuse for someone to say, well, I don't have the money, I don't want to get one. Everyone needs one over the age of 18.
Is there a certain time in our lives when we should be thinking about doing this, or any time is right?
Any time is right, especially with the medical power of attorney. So many of my clients, as their children are going off to college, they've finished high school, I remind them that they really should get a medical power of attorney, because if a child at the age of 20 is in a car accident, the parent doesn't have the right to make the decision unless the child has filled out one of these documents. So it's extremely important to have a medical power of attorney.
Now, what if someone doesn't have these documents and they become incapacitated? What happens next?
And, oh, Lauren, that happens a lot. So what happens in that case is we have to go to court. And it's heartbreaking for me because it's so much harder for the family. It's expensive. It's emotionally draining. And when we go to court, it just stretches everything out. I had a son recently whose mother had a stroke, and she didn't have any documents, so we had to go to court. And I actually saw this son change from he was so sad about the situation, he got angry at his mom that she never did documents, so now he's spending all this time going to court and setting everything up. So if you don't have these documents, for the financial power of attorney, we have to set up a conservatorship. If someone doesn't have a medical power of attorney, we have to go to court and set up a guardianship.
All right. Well, Carol, is there anything else related to these topics, anything else you want people to know today?
Well, I actually want to talk back about the wills and trusts because I'm asked every day, what is the major difference? And the major difference between a will and a trust is a will only works after you die. And I mean, that seems so obvious, but a will is necessary for younger people if you have children who will raise my children, but a trust lives with you. So the basic difference is a will is only after you die, a trust lives with you, also works after you die, but we need a trust if someone is going into a nursing home and we want to get their assets protected. So it's important to talk to an elder law attorney and find out what document is best for me.
Perfect. Well, Carol, thank you so much again. This is a lot of good information for us to keep in mind. We appreciate you.
Thank you, Lauren.
Of course. As always, you can find more information on today's topics if you just go to our website, visit the hot link section at WNEM.com.